Good evening to everybody. Thank you for coming upon the invitation. We have gathered in this lovely evening to present our probate case. Before that, I would like to wish our beloved lecturer, Syed Ahmad, sir, along with me. First, I would like to introduce our partners. We are from Group 3, myself, Miss Barry. Along with me, we have Miss Shooting. We have Miss Akila Aidani, Miss Najwa Cheswani, Miss Nur Salama, Miss Adriana Batrisha, and also Miss Ibtisam. Without further ado, I would like to present on the introduction of the case presented by myself. Hello, a very good day to our lecturer, beloved lecturer, Sir Ahmad Al-Baiti. Now, myself, Ms. Pari, Nita Krishnamurthy, on behalf of number 3, will now introduce to the facts of the case in the Udham Singh and Indar Kaur, case of 1971. Now, the testator, Mr. Wandewa Singh Man, has two wives. The first wife is predeceased. The first couple has two children. Number one, Udham Singh, the appellant, and second, a daughter. And the second couple, which is Mr. Wandewa Singh and his second wife, Mrs. Indar Kaur, who is the respondent in this case, has four children together. Okay, after coming to the Singaporean Hospital, Gleneagles Hospital, on 15th March. On 24th of March, the testator complained of head dizziness and drowsiness. And 2 days after 26th March, the execution of the will happened, which is the signature of the testator with the lawyer and the appellant family. Now, after 2 days, just 2 days, on 20th of March, the testator developed into hypostatic pneumonia and eventually died, left the world on 8:30 p.m. at the night on the same day. That's all from me. Now I will pass to my next member. Thank you.
Thank you, Ms. Pari. I will now present my part of this presentation, which is the decision of the case.
Now, moving on to the decision of the court. Now, in this case, it was held that the appellant submission in regards to the judge decision was in fact correct. Now, in the appellant submission, it was claimed that the judge had erred when he put the burden of proof in regards to testamentary incapacity on the appellant. Now, the court had come to this conclusion by referring to the case of Smee against Smee, in which in that case, it stated that the onus of proving the testamentary capacity should fall on the defendant. And also stated that if there is evidence that show the person making the will is of unsound mind, then the burden of proof should lie upon the person claiming that the person making the will made the said will during their lucid interval.
Okay, thank you to my partner, and I shall now continue the decision of the case. Okay, the argument on the authority of Tyrer versus Paynton by the appellant was denied as the facts of the instant case was not in dispute. This case argued on the validity of the will as there was a fraud on making the first will, and the judge on this case had failed to consider the suspicious circumstances when the second will was made. However, the instant case had only one simple will and no fraud in question. The judge also concluded that there was no undue influence issue arises. Thus, the learned judge referred to the case of Pickup versus the Thames and Mercy Marine Insurance Company Limited for retrial, as there was a misdirection which resulted a wrong burden of proof on the appellant, which was supposedly on the respondent, which is the defendant, to prove the capacity of the testator in making the will. So it was held that a retrial should be ordered. That's all from me. I shall now pass to my partner. Thank you.
Thank you, Ms. Najwa. Okay, now I will present the part of ratio decidendi of this case. So the court referred to the case of Bank and Goodfellow, which that the court held that a person has testamentary capacity if he fulfill specific requirements, which are when he understands the nature of his act of its effect, the extent of the property of which he is disposing, the claims to which he ought to give effect. No mental disorder affect his affections, his sense of right, or prevent him from exercising his natural faculties, no insane delusions affect him in disposing of his property, and if he is sound mind, such act would not be done. And further, the court also referred to the case of Smith and Smith. If the above point was taken, the owner's probability of proving such testamentary capacity should be laid on the defendant. So further, the judge also referred to the appeal case of Terrier and Penton to discuss the instant case. So the main issue was whether the testator had a free disposing mind must be established by the respondent before discussing another issue of undue influence, since there is no allegations of fraud. However, the learned judge had wrongly put the onus on the wrong party, which is the plaintiff, to show that the deceased had no testamentary capacity. Next, I will pass the floor to Ms. Nadia Matisha. Thank you.
Yes, thank you, Ms. Chanshuti. So I will take over now. The next point of the ratio decidendi is that the judge decided that there was no consideration given to certain circumstances. That is, firstly, where there is no consultation with Dr. Gethin Jones or Professor Ransom as to whether the deceased was in a fit condition to make a will, since the will was done in hospital. Not only that, there was no examination of a deceased by the doctor before executing the will, and there was a failure to summon any hospital staff to give evidence on the mental capacity of the deceased or the effective executive of the will. Not only that, there was no hospital staff that become the witness of the will. And the deceased thumbprint was not involuntarily. And lastly, the defendant admitted that the deceased was seriously ill, not knowing nothing about the will with the thumbprint, and it was done by him and his mother. Thus, there is no contradiction of this evidence as it was not controverted. So the learned judge failed to address such issues before concluding that there was no undue influence, but only assessed them in the context of plea of undue influence. Nonetheless, it should be the respondent to explain them before dealt with the issue of undue influence. Further, the judge also referred to the case of Pickup and Thames and Mercy Marine Insurance Company Limited, where it was misdirection to put the burden of proving the unseaworthiness arose causes occurring the subsequently to setting the sail. Therefore, the onus to prove the testamentary incapacity should not be laid on the appellant, but it was the burden of proof of the defendant to prove that the deceased has the testamentary capacity to make a will. That's all from me. I shall now pass to the next part.
Okay, now I will proceed with legal opinion. The testator must comply with requirement to execute a valid will, such as sound mind, lucid interval, age of majority, intention to make a will, freedom of choice, and formalities. In this case, so that the testator can understand his action and their consequences, as the evidence stated on March 24, 1961, the disease had a relapse of thrombosis and become drowsy, discontinued for the next few days. In such circumstances, it will be almost impossible to know the beneficiary and the disposition of the property. The question remains to be discussed whether the creation of the will was done during lucid intervals or the testator or vice versa. Besides, the intention to make a will must be made freely without any force by others. However, it is doubted in this case that the testator has no freedom of choice, as he has been excessively pestered during the execution of the will. First, referring to the evidence by the nurse of the hospital, there was no response from the testator when he was asked regarding the distribution of the estate to the respondent. Second, the lawyer was pressured to make another attempt to obtain the response from the testator. Next, the testator thumbprint on the will was not obtained voluntarily by him, as well as it was physically placed on the will by the son with the help of the solicitor. Therefore, we opine that the will was tainted with excessive pestering, and hence the validity of the will has been defective. Now I will pass to my partner, Ms. Nur Akila.
Thank you, Ms. Salama. I am Nur Akila and I will present our second point. In the trial case before, the judge has failed to address certain suspicious circumstances that occurred during the execution of the will, as mentioned by the appellant. Among the suspicious circumstances is that the will was done with the knowledge and approval of the mother, and she was made the absolute and sole beneficiary of the will. And although the will was done in the hospital, no attempt was made to get the opinion of Dr. Gentin Jones or Professor Ransom as to whether the deceased was in a fit condition to make a will, as mentioned by my friend earlier in ratio decidendi. Nor was any hospital staff was asked to be a witness to the will. In our opinion, these circumstances need to be considered meticulously by the trial judge before deciding on the said case. Furthermore, the judge has failed to scrutinize the validity of the will when he placed the burden of proving testamentary capacity on the appellant. A testator is presumed to be sane at the time when he made that will, but if the will is contested on the ground that the testator was of unsound mind when he made it, the person propounding the will has the burden of proving that the testator was of sound mind. In the previous trial case, the judge has erred in placing the burden of proving testamentary capacity on the plaintiff. This is because the defendant propounded the will and alleged the validity of the will. Therefore, the onus should be placed upon the defendant, which is the reason we agreed with the current judge decision to order a retrial to correct the error of placing the onus. In conclusion, we believe that the testator or deceased has failed to fulfill some requirements to create a valid will, such as sound mind, lucid intervals, intention to make a will, and has failed to follow the formalities of freedom of choice due to the circumstances of the case. Moreover, suspicious circumstances that occurred during the execution of the will need to be observed to determine the validity of the will. Besides, misdirection on part of the judge in putting the burden of proving the testamentary incapacity on the appellant needs to be corrected to ensure every person's right to the property of the deceased can be protected. Hence, we agreed with the decision of the federal court that a new trial need to be held. That's all from me. Thank you.